All right, cool. Well, welcome everybody. And the we're going to do is sort of as was indicated, we're going to do a brief introduction into sort of these legal roadmaps and the sort of the process, the kind of questions that you guys are going to talk about in your little groups. And then we'll break up into the groups, and you and the lawyers and the entrepreneurs can get together and talk about what they're doing, and walk through it. And then at the end of the day, the law students will produce a legal roadmap, which is sort of a little summary of what the things you might think about. And so you'll implement during your room the things we're going to talk about very specifically as it relates to your startup. So that's kind of cool. And it's a good experience for the law students and for you guys to sort of get a leg up. A couple cautions about it. One is, the law students are, there's no attorney-client privilege here. So don't tell them confidential information. Don't tell them your trade secrets. Don't tell them the secret sauce. This is not there's no confidentiality. So keep it at what you're going to do at a fairly high level, enough that they can can help you, but don't give them the trade secrets. And aside from that, I think you'll find it to be entertaining. What I'm going to do first is sort of walk through the worksheet that the law students will work from, and sort of talk about it more generally, why we're asking those questions and the significance of it. And then, as I say, you'll walk through it a little more specifically in your groups. So let me, if I can, share my screen. This is where it does a little talking while I figure it out.
I was thinking about doing a song.
There we go. How about that? See that? I even got applause. So that's good. You can see it. All good?
Mm-hmm.
Cool. All right. So, you all have this. So I'm going to, it breaks into the description of the business, and then we'll talk about the form of entity. Then you'll talk about founder and prospective employment consulting arrangements, equity arrangements of the founders, and governance and shareholder and a little bit of employee equity. So those are the areas. And we're going to start with the very easy thing, which is sort of just a little bit of description. It's just nice for for your lawyer to know a little bit about your business and understand what it is you're trying to accomplish. And so we kind of like to ask in the 2A, what's the product service will you be selling? The name of the business, I've told people many times, don't spend a huge amount of time on this. I care a lot more about the name of the product and service. But if you're going to pick a name, you want to make sure it's available. So they're going to ask you what the name of the business is, and then at some point you're going to check, like if you're going to be in Delaware, check the Delaware, see if it's available, make sure the domain is available. So question one is what name are you thinking about? And you guys can even go online and see whether it's available. Go to the Delaware Secretary of State and see if it's available for fun. Part of what we're going to talk a little bit about is it asks whether you're in these in item 2, personal services, banking, insurance, blah, 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 blah. And that seems kind of a bizarre question. I don't know if to the extent that you guys were in the session last week, that was a whole week ago. We talked about sort of the difference between limited liability companies and C corporations, and some of the benefits of being a C corporation. And one of the things that's available for it is under section 1202, which is the small business treatment, being the small business stock, and it has the benefit of favorable capital gain treatment when you sell the company, which is to say, if you hold it for more than 5 years in your specific kinds of businesses, you actually get at the moment 0 capital gain. And the current legislation point is for 50% reduction of capital gain, still very favorable. Certain kinds of businesses don't qualify for that. So the law students are going to ask you on item B, are you in one of these? Are you in that kind of business? Because those are businesses that don't qualify for 1202. And so that's why that 2B question was in there. And we want to know about the kind of business products and services and what's unique. We don't talk a lot here about why we care about it's unique, but one of the things that when you talk to a lawyer upfront, they'll care about that because you want to know what kind of IP can you protect. And frankly, from a business purpose, you want to know what's unique about the product or service, what's going to distinguish you from others. And so that's a good thing to think about upfront. So that's one of the reasons we start there. Just basically a little intro, getting to know each other. Then we want to know, the lawyer is going to want to know, who are the initial shareholders? Are they going to be more than one? Who are they? And are you going to license any technology from folks? If are you going to have to license it from the university? So let's make sure we have a full understanding of who the initial shareholders are. Question number 2 is, who's a character of the individual, corporate, or partnership? The reason for that question is the third kind of entity could be an S corporation, which has the benefit of being a fairly simple, has the pass-through treatment that we've talked about in our last get-together. But it can't have shareholders who are either individuals, corporates, or partnerships. So that's the reason we asked for that. And you see a footnote for the cheat sheet there. If you're one of those things, then you're out. Again, S corporations is not available to you, so that actually makes that pretty easy. Similarly, if it's a U.S. citizen, if you're not a U.S. citizen, you don't qualify either. And we're, next to number 4, where's the capital of the company? Who's when people get together to start a company, you want to know where's the money going to come from? Who's going to capitalize it? How much do you really need up front? Where do you plan to get additional capital? Do you plan to get it from venture capital funds? Items A, B, or C are for the lawyers to help you think through the capital structure going forward and how much equity people are going to get, and do you need to structure as a loan? The fourth question is a little tricky because if you're getting venture capital funds, again, they probably, you probably won't want to be a limited liability company. Venture capital funds don't fund into a limited liability company. So when I'm choosing which entity, if you say if you say that you're going to venture capital funds, then I lean toward a C Corp rather than LLC. So I'm still trying to figure out, as I'm going through this, do I want to be an S Corp, LLC, or C Corp? And here, if they're going to ask you this, and if you're going to lean toward venture capital funds as part of your financing, you probably don't want to be a limited liability company. Then we're going to ask you a little bit about your exit. Would you plan to own this for 5 years? Do you think you'll distributions, dividends, and when do you think it's less likely that you'll sell? Actually, A and C are sort of duplicative. And again, the reason for the 5 years is in order to qualify for this qualified small business stock 1202 that I was discussing, you have to hold on to it for 5 years. So if your expectation is you're going to flip this thing real fast, then that's really not a consideration. And so you want to, so that'll help the lawyers figure that out. If you plan to make dividends and distributions, then you probably in BI, you probably want to think about an LLC, because if you're basically going to license and the technology and have a bunch of dividends paid out, then you'll pay double tax. So you're better off to be an LLC. So again, these questions are oriented toward what kind of entity are we going to choose. The last set of questions we talked last time a little bit about benefit corporations. So let's think about whether we want to be a benefit corporation. 99% of you probably will not want to be, but at least we want to have the question. Are you planning to produce a public benefit or operate in a responsible, sustainable manner? That's question 1. Question 2 is the source of capital consistent with a benefit corporation, which is, are you going to obtain funds from an investor or a capital source that looks favorably on this? If you're going to get it from your funds from typical angels or typical venture capitalists, probably not. If you're going to go to socially responsible funds, that's a different entity, or foundations. So let's look at where the source of capital is going to be and whether they're compatible with that. And frankly, are you willing to, if you really want to go to the benefit corporation side, there's some additional reporting and disclosure requirements. You got to report to the shareholders as to how you're doing at achieving your public benefit. You got to, and you have to. So there's a bunch of called red tape. And so is that something you'd like to undertake? So those are all designed to help us figure out what kind of entity. And so they're going to walk you through that. Then we get to the founder and prospective employment consulting arrangements. And here we want to make sure that we, first of all, clear the shareholders. I call it clear the shareholders and the founders. And this is, are they under obligations that are going to be a problem coming into this? Do they have any employment agreements under which they have invention assignment agreements or non-competes? Are there any policies that they're subject to? Confidentiality, invention assignment agreements. Where do they work? Where did they work? Did they work for a university such that the university actually owns their IP? They work for a private company, and so they own their IP. So I want to probe around and go around the shareholders, the founders, and say, okay, where you been? What have you been doing? And try to probe around and see if anybody else own the IP that they're now going to put in here, or have any non-compete obligations that we should know about, or confidentiality obligations. And then let's spend a little bit of time on what role each of them are going to play. Who's going to be, are they going to leave the university or leave their current employment, work here full time? Are they going to play the CTO, CEO, CFO, chief bottle washer? What role are you going to play? And are you going to be full time? That's both so we can think about the employment arrangement, consulting arrangement, but it's also intended, as you'll see, it'll get a little bit into how much equity and how we divide up the equity. So that's some background for that. What's your anticipated compensation? It's good to know what arrangements people have, not wait, do the founders intend to be paid, et cetera. We want to understand what the founders, so there's a thorough understanding before we form this company. And you've thought about, are you going to subject to non-competes? Because I hate to enter into a deal, start a new company with Jeff Locker over there, and he and I are starting a new company, and then we get all set, and then he goes and starts up a new competing company. I hate it when that happens. And so, do we want to start some kind of a non-compete arrangement? Yeah, I mean, certainly during the period. Is there a period of time afterwards? Typically, there's like a 1 to 2 year obligation afterwards. They're willing to do that. Are they going to sign a non-solicit? So they're not going to solicit the customers. I mean, I hate to get this company up and the founders go and start soliciting the customers. So are we going to have that kind of a thing? Number 6 is really important. Is when we form this entity, are all the founders available to sign invention assignment agreements to the company? So whatever IP they created, they're now going to put it in the company. And as important, current and prospective, when they're doing work for the company going forward as a consultant, advisor, or employee, are they willing to assign their inventions that they create for the company? Really important, because we've got to make sure that the company owns the IP both back and forward. And if they get fired, they're going to get severance. Less important in this case. Okay. Let's get this 1 second. Yeah, I'm going to go to number 5, then I'll come back to number 4. Are we going to, now we're all going to have all these founders together. What kind of a share, who's going to be on the board? Who's going to run this thing? Have you decided on who's the board of directors? I mean, if it's a corporation, the shareholders appoint the board of directors. If it's a limited liability company, you appoint the board of managers. So who's going to be on the board? Who's going to be the officers? Have you thought about, are there any issues or decisions that are going to be made that require a supermajority of you? So if there's 3 of you or 4 of you or 5 of you, is there anything like sale of the company or issuing additional equity that you want more than just a majority to decide, supermajority? Who's going to make the big decisions if we're going to sell the company? Who's going to make those decisions? And number 4 is the shareholder arrangements, the shares, the transfer, which is, Carrie's on the line here. I hate to start a company. Well, how about Carrie and Jeff starting up a company? And then Carrie decides, she's going to transfer those shares to, of all people, me. So instead of having Carrie, who's very nice as a shareholder, a fellow shareholder, now Jeff has me as a shareholder. That's not what he wants in life. And so do you want some prohibitions on those transfers? Is that okay? Maybe subject to board approval, maybe right of first refusal in the company. So talk through a little bit whether or not there's going to be restrictions on the transfer and what those would be. We also probably want to think about, once we figure that capital chart and who owns what, which we're going to get to in a moment, you're going to reserve some for employees. This is the kind of thing where you're going to have you reserve some stock. Maybe 15% is pretty difficult to reserve for the employees. And did I skip it? Wait a second. I did have it here. It's okay. Yeah. And will the employee actually be subject to vesting? Let me go to the employee, the founder's equity. I'll get in a moment to the amount each person gets, and we want to figure out sort of how much each shareholder is going to get, and that's a good thing to walk away from this and have a sense of how much. But one of the things I want to know is, in the vesting area, are they going to vest over time? I mean, again, go back to Carrie and Jeff starting a company. They own 50-50, not perfect, but they own 50-50. And the day afterwards, Jeff decides, yeah, I really don't want to do this. I'm going to go work for Google. And now Jeff owns 50% of the company. Not a good plan. So sometimes we have the equity vest over a period of time. So the question one is it going to vest over time? And if so, what's that period going to be? 2, 3, 4, 5 years? So, I mean, clearly, if Jeff's there for a couple of years and then he decides to go work for Google, he should probably own some of that company, but he shouldn't own all of it. So what percentage is he going to own? And what's if we sell the company, sometimes you have an acceleration of that. So you can accelerate it on that point there. If he resigns, terminates without cause, and if it terminates, the company decides to terminate Jeff without cause. So they just decide to get rid of him. Should he really lose his equity or shouldn't he? Usually we say, you know what, you lose that which is not vested, but that's a question. So those are things you want to think a little bit about. So let me talk for a moment about how much stock each person gets, because one of the things that you all have to decide is you have to look around and say, okay, how much am I worth? How much of this company does everybody get, right? And there are a lot of solutions. And if there are 5 founders, one solution is, this is really easy. I'm going to take 100. There's 5 of us. 100 divided by 5 is 20%. Even I can do that math. So we all own 20%. That is one way. It's not a perfect way, because it turns out that you're going to give different amounts. I mean, you're going to have different contributions. And one of the mistakes that I think I've found more often than others is that we have equity going to people who really aren't contributing going forward. So it's really want to give it to people who are really valuable to the company, and that's really important. So one of the things you're going to go through in your little groups is what's called and I'm going to stop sharing here for a moment. And let me just go to this. So there's a fellow by the name of, and you guys have probably been through this before, and if you have, I apologize, but there's a fellow by the name of Frank Demler, who I've known for longer than I care to admit, and certainly longer than he'd like to admit. And he came up with the founder's pie chart. And what he says is, look, there's a methodology. This is one means by which to allocate the equity among the founders. It is not perfect by any stretch, but it sort of forces you to have a conversation on the subject. It forces you to allocate it. And it gets pretty close, actually. It's not perfect, but it gets pretty close. And what it says is, look, let's take some of the things that founders provide, the value that they provide. First, there's the idea. Somebody brings an idea to the table. Now, that's worth something. It's not everything, but it's certainly a start. There's the thing about 1% in perspiration, 99% perspiration. So it's not all about the idea, but there's some of it. What else do you need as a new company? Well, there's business plan preparation. Somebody has to develop a business plan. Answer my favorite question: what are you going to sell to whom, for how much, and make money out of it? Right? You got to explain that to people, and you need to be able to develop that business plan, and that takes an understanding of what you're going to do. It's really, really important if you're going to raise money, because you got to have a business plan of some sort to do that. So that's valuable there. Some others not as important. Somebody has to have domain expertise. Somebody needs to understand what it is that you're trying to accomplish in the business itself. So that's kind of important. Commitment and risk is important too, which is that some people are going to actually jump ship. They're going to leave their current employment. They're going to go work for this and give up good opportunities to work for this full time. That's commitment. That's risk. And so that's worth something. And that's going to drive it, right? And another one is responsibilities. Somebody has to drive the vehicle. Somebody has to be in charge. And so who's going to be responsible at the end of the day? Is somebody really going to be responsible for this when we're done? There's others. There's nothing perfect, but these are 5 examples. So using his pie chart, he says, okay, let's take those things and weight them. So I think, and give them a thing between a value of 1 to 10. So for example, the idea is pretty important. So maybe he gets a 4. Business plan, kind of important if you're going to go raise money. Not as important if you're just among each other, but still important. Domain expertise, you really do need somebody to understand it. Commitment and risk, essential, right? I got to have somebody who's going to really jump in and drive this. And somebody's got to take responsibility. So I'm going to give those weights from 1 to 10. So I'm going to go down. I'm going to say, okay. And then I got to assign for each of these founders one of these things, right? Then I'll do it. So then I'll multiply them out and get a weighted average. So let's use an example. And he has, Frank had an example of, okay, you got the inventor who's the technology guy. He's the leader. He's the guru. Inventor, i.e. guru, right? Business guy, he's the one who's going to drive it. He's the one who's going to bring the business industry knowledge, et cetera. The technologist, who's sort of the right-hand guy, but not really the guy. And the research team member who happened to be there, did a little bit of work, not driving, it's driving it, and not even leaving the place of employment. So those are my 4 founders. Nobody thinks the best way to solve this is give each one of them 25%, right? So that makes no sense. So let's see what works. So he says, okay, let's give these weights. Let's give, and this is arbitrary, but he says, okay, let's give the weights, the idea, 1 out of 10, a 7. Business plan, a 2, because it's not that important, they're not raising money. Domain expertise, 5. Commitment and risk, really important, 7. And responsibility, somebody's going to drive it, 6. Founder 1, our guy with the inventor and who knows everything. He gets a 10 for the idea. He'll help out with the business plan. He's got no domain expertise. So he gets a 6, 1 out of 10 there. He's staying at the university. He's staying what he's doing. He's got no responsibility. He gets 0s there. Our business guy, he's got some part of the idea going forward. So he gets a 3 there. He's developing the business plan. So he gets an 8 there. He's learning about the domain expertise. He's taken the commitment and risk, and he's got responsibilities. He's got a 6, and so forth. So you get the idea. And then you do the multiplication. So you weight these, you multiply them. You take so you take the 7 times the 10. You come up with this. Is so exciting, isn't it? And then you come up with the then you add them up. And you do all the math, and et cetera. And you'll see that you end up with these percentages. You do the numbers, you do the total, you get the percentages, you get the math. Law students, you need all the others will help you. So, but the point is, so let's go back and review and see where they ended up. Notice that the business guy who's leaving, going to drive and all that, has 44.2%. The guy that had the guy or the woman had the real idea and it's got 33%. The person who had the right-hand person has 16.5%. And the research person who happened to be at the right place got 6.2%. Are these numbers perfect? No. But do they give you a general sense? Yeah, it's not far off. And then when I see in the marketplace, this is actually pretty close. So it's actually pretty good. So that's the process by which you're going to go through. You're going to go through this process. If there's only one of you, by the way, of the founders, it's going to be really easy. But there's that. If there's 2 of you, you're going to get into the 50-50 thing as to whether you do 50-50. And and we talked about last time, that's not perfect because who makes the decisions and who's going to really drive this, who's going to be really in charge. There are some ways around. You can do what's called a shotgun provision, which the lawyers can tell you about. And it's not nearly as bad as it sounds, but it's simply somebody throws up a number and then somebody else, and then you have to buy or sell at that price. So that's one possibility. Another is to have an arbitrator. You appoint a third board member, or actually things can go to arbitration. So you have to do a 50-50. There's some decision making, some ways around it that you need to think about. So in our little group, let's go down. Stop sharing. So in your little group, you're going to go through the worksheet. You're going to go through the Demor's pie chart. You're going to come up with some of a legal roadmap. And again, if you walk through these issues, which you won't conclude, but you'll have thought it through, you'll be in a really good position when you go meet with your lawyer, eventually when you start your company, and you'll have be well on the road. Let me shut up there and answer questions before you break into your groups.
We already got one, David, and I don't know if this will challenge you technically, but is there any possible way you could put a link to that document in chat?
It would challenge me. So it would totally challenge me. Huh?
Colleagues could do that.
Yeah, I sent it to you guys this morning or yesterday. So I sent both documents to Stephanie, Kit, and Rhonda yesterday.
Yeah, the law students should all have a copy of it because I posted it on our Canvas site.
Well, this is actually came from a participant.
Yeah, so you guys, so I'll push it back at you, Kit. Can you do that?
Okay, I'll send it off to Jess and she can do it.
There you go. Cool. So here's a question that says, how are the weights selected for the founder's product characteristics? Will this be discussed during? I can't see the rest of it, but the answer is it's subjective, and the weights are based upon what you think the important traits are. And so, and there's two different weighting. One is if you think, this, for example, the idea here is really important that we have the formula for Coke, then the idea is really, really important. If this is the deal where it's really all about implementation and commercialization, then I'm going to weight heavier the business person who's going to actually drive this thing. And so there's no perfect thing. It's a judgment case. It's sort of what kind of business it is and what's really important for this going forward. And then similarly, when I get to the people, I'm going to weight that too, because I'm going to weight their contributions as it relates to each one of those items, categories. So that's the judgment that you'll have to make. And the good news is once you go through it, they're not that sensitive. So one or two off isn't going to make a big difference. So don't kill yourselves over a 5 versus a 6 versus a 4. It's too much brain damage. The idea is to get a concept, and you'll get relatives when you get done. So don't kill yourselves over it.
So David, I don't know if you find this technique good or not, but what I've often recommended to my co-founders is each of you go into your own room and do your weighting and do the assignment, and then come back and compare, so that one doesn't sort of dominate the conversation. And this is going to be, in some ways, the easiest discussion you're going to have. And so let's just say you rated one category as a 7 and the other person did a 3. Well, talk it over about why you saw it differently, and then come up with a different number. And you'll see how well good founders disagree agreeably and find a way. They're not trying to be right, they're trying to do right. So
I always joke that I think you're absolutely right. First of all, I think that's a wonderful approach, and I highly encourage it. 2 is you do find whether you can disagree agreeably, and that's pretty cool. And if you can do that, I'm unique, and I'm able to agree in a disagreeable way, and that takes a special skill. Just joking. Yes. Yes. Other questions? Those are really good questions. All right. Again, not subject to attorney-client privilege, no confidentiality. So don't be giving the secrets to the Coke